We continue the 14th and final book, Laws of Sanhedrin, Laws of the Court. All right, chapter 7. The following law applies when one of the litigants says, let so-and-so act as a judge for me. The other litigant says, let so-and-so act as a judge for me. Together, the two judges, which were chosen by each of the litigants respectively, choose a third judge, and the three of them adjudicate the case for the two litigants. In this manner, the true judgment will emerge. Right. So, did you ever hear of, you choose your judge? You be the judge, right? Well, here's the interesting law. Yeah, you could, if both litigants agree, right? This is called Beirin, that you choose. Each one chooses, in a sense that each one's choosing someone who they feel will side with them, but the two of them decide who the third one will be, right? And then and of course they have to be judges, right? And then you can go to litigation and do such a thing. Even a judge chosen as one of the litigants is a great sage who has received smicha, and one litigant cannot compel the other litigant to have him adjudicate the case. Instead, he also chooses a judge he desires. Okay. Halacha number 2. The following rules apply. When a litigant accepts his own or an opposing litigant's relative, or another person who's unacceptable to serve as a judge or a witness in his case, right, that becomes a judge. If he affirms his commitment with a kinyan, he cannot retract his consent. If he did not affirm his commitment with a kinyan, he can retract his consent until the case is concluded. Once the verdict is rendered and the unacceptable judge ruled in his verdict, or a verdict was rendered on the basis of testimony of an unacceptable witness, the money should be expropriated. The litigant may not retract. The above laws also apply if a litigant accepted a person who was disqualified because of his commitment, he committed transgression, or has two witnesses to testify concerning him, or has a court of three judges to rule concerning his interests. Similarly, if it applies regardless of whether he gave his consent at the risk of forfeiting rights and waiving a claim that he is pressing, or he gave his consent at the risk of having to pay what the plaintiff demands of him because of the testimony of an unacceptable witness, or because of the ruling of this unacceptable judge. So, right, so you can't have a relative, you can't have a judge, an unacceptable judge, you can't have a witness of the case who now becomes a judge. Right. So if the litigant did not affirm his commitment, right? So he can retract because he did not accept. All right. The question is if this is a valid, a court, right, to make a judgment. So if you didn't make a kinyan, meaning, you lifted up, you said, okay, I'm accepting these judges, right? If you didn't do that, for example, so you could retract. But once the verdict is rendered, right, in this court that is not fitting, the money should be expropriated. The litigant can't retract. You were okay with it. You lost the case now. You can't complain now. Okay. Exactly. Yeah. Of course, we're only talking about a case where you lose. Right? Okay. Similarly, the following laws apply when a person was obligated by a court to take an oath to a colleague, and the person to whom the oath must be given states, take an oath on your own life and be freed of liability, or take an oath on your own life that your claim is justified, and I will give you everything that you claim. If he affirms his commitment with a kinyan, he cannot retract his consent. So we're talking about in a case, the court says you need to take an oath based on what your claim is, right? He said, well, I don't want to take an oath, right? I want you to take the oath instead, right? You take the oath. And if you take the oath, then I'll give you whatever your claim is against me. All right. So if I make a kinyan, right, which means an act of acquisition, and I was just accepting this ruling, right, meaning accepting that the person, the litigant, can make the oath, and he takes the oath, and therefore I lose because of that. I have to pay. I can't retract, right? If he did not affirm his commitment with a kinyan, he can retract his consent until the case is concluded. Once the case is concluded and he took an oath as stipulated, he cannot retract and he's obligated to pay. Okay. Similar laws apply. Number 4, when a person was obligated to take a shuas hesed, which is rabbinic oath, and he reversed it and obligated the plaintiff. Right. So the defendant, let's say whatever the case is, like he was a guardian for right, for something for the plaintiff, and he says that it got lost, and he didn't get paid for it, right? So he's not obligated to pay. I don't know if this is a good example because you can't reverse it over here. It's not a good example I just gave because you can't reverse it because the plaintiff can't make an oath because he can't say, well, he could if he said, well, I was in your house yesterday and I saw it there. And you said you lost it 3 days ago. So maybe he could. I don't know. Okay, whatever the case may be, in a case where the plaintiff could take an oath, right? This is a rabbinic oath. And he wants to reverse it, the defendant, and obligate the plaintiff. If he affirmed the consent with a kinyan or the plaintiff took the oath, the defendant cannot retract. So if he, right, he said, okay, I'm allowing the plaintiff to do it. He can't now retract. The plaintiff has the right. Or if the plaintiff took the oath without the kinyan, right, without the acquisition, then he can't retract. Similarly, interesting why these laws are here and not the laws of oaths. Similarly, when a person was not obligated to take an oath, and yet he said, I will take an oath in response to your claim. If he affirmed the statement with a kinyan, he cannot retract. Right? So I'll say, okay, I'm not obligated to, but I'm ready to take an oath. And made a kinyan, I can't retract, I have to take the oath. Remember that oath is a serious thing and people don't want to take an oath, right? So if he did not affirm the statement with a kinyan, he has a right to retract until the judgment is concluded. And he can actually take the oath even though he made a commitment in court. Okay. Number 6, when a person was obligated by a court and then brought witnesses, obligated by a court and then brought witnesses or proof to vindicate himself. So he's obligated by court, right? Yeah, you got to pay. The court obligated you, right, for whatever it is. And then you brought witnesses or a proof to vindicate himself. The judgment is rescinded and the case should be tried again, right? So this is after the court made a judgment. But now I have proof, right? I couldn't find my witnesses before. They were out of town. They were whatever, gone missing, right? They came out of Gaza. I have proof now, right? So the case needs to be retried. Although the judgment was already rendered, whenever he brings support to his claim, a judgment is rescinded. Even if the judge tell him, bring all the proofs that you have within 30 days. A litigant may have a judgment rescinded, although he brings proof after 30 days. What can he do if he did not discover the proof within 30 days, but found it afterwards, right? So he has the right that he didn't find it before. Again, it just came out of Gaza. And they were a witness to this litigation, Halacha number 7. If, however, the litigant completed stating its claims, he cannot have the judgment rescinded. What is implied? The judge is asking, do you have a witness supporting your claim? He says, I do not have a witness. Do you have proof of your position? I do not have proof. In such a situation, if the court judged him and held him liable, the judgment is not rescinded. Right? He should have said, I do have witnesses, but they're in Gaza. Or they're, I don't know where they are. I've been looking for them.
But how could he doesn't no evidence, no.
Well, he said, no, the court asks you, do you have witnesses for you're making a claim. Do you have witnesses for your claim? Huh?
You should have witnesses.
That's not what you should or shouldn't. That's not the point. Question is, the court asks you. And if you said no, so you can't come back and say, oh, I forgot, I really do, but they were out of town.
Oh, okay. Yeah.
Right? So you should have said, I do have witnesses, but they're out of town. So they're going to proceed, either they'll wait, let's say, whatever. I don't know if that's a good example because maybe they'll wait for the court case if they're out of town, right? But let's say they're not waiting for whatever reason. Right? And then they do come. So in such a situation, if the court judged him and held him liable, the judgment is not rescinded, although when he sees that he is being held liable, because so and so is forward, I came forward and testified on my behalf, or he produced the written proof from his money belt. It is not significant. We do not pay any attention to his witnesses or his proof. He had to say that from the beginning. He can't now always, because he sees a judgment being held against him coming, right? Halacha number 8, when does the above apply? When the proof was in his possession and the witnesses were together with him in the country. If, however, he said, I have neither witnesses nor proof, and after all, my example was not good. And after his witnesses came from overseas, or the leather satchel belonging to his father, where legal documents were held, had been entrusted to another person, and that person came and supplied, he didn't know about it. Right? His father passed away, and he didn't know that someone had that. That's different. He may call on his witnesses and or this proof and have the ruling rescinded. So I don't get it about the witnesses, because you had witnesses. Why didn't you state it to begin with? If the satchel, your father passed away, right, and he gave a satchel with evidence to someone and you weren't aware of it and he just came forward, oh, that makes sense. But you knew you had witnesses and you knew that they were out of town. That should have been stated, seemingly. Huh?
It's misleading the court. Because if they ask you, why say no?
Yeah. I don't get that. Okay. Why may he have the ruling rescinded? Because he could claim this. The reason I said I don't have a witness, I don't have any proof, is because they were not available to me whenever he could. Okay, so now he explains it here. Whenever he could make such a claim, and there's substance to his words, he is not considered to have stated his claims when he originally stated, I have no witnesses. He may bring witnesses and or prove and have judgment rescinded. So it would seem to me that the court should ask him, do you have any witnesses? And if they say no, do you have any possible witnesses? You just can't find them now? So they should say that, I would think, based on this. Accordingly, if he explicitly stated, I have no witnesses at all, okay, here, neither here or overseas are any written proof, neither in my possession or possession of others, he cannot have his judgment rescinded. Right, okay. It seems to me that the court should ask it that way. When does the above apply? Number 9. With regard to an adult who was held liable and then brought written proof or witnesses after completing the statement of his arguments. Different concepts apply. However, with regard to an heir who was a minor when the person whose estate he inherited died, right? And the suit was lodged against him because of that person after he became of age, right? So he inherited it when he was a minor. So then you don't expect that he's going to know, right? Not going to know. Even though he stated, I have neither witnesses nor proof. And after he departed from the court, after hearing being held liable, others told him, we know testimony that favors your father that will cause this judgment to be rescinded. Or the persons whose estate you inherited entrusted with this written proof to me. Right. He may bring the testimony or proof immediately and have the judgment rescinded. The rationale is that the minor is not aware of the proofs possessed by the person whose estate he inherited. He's not going to know that. He was a minor. But interesting, only a minor if he was an adult when he inherited, right? It sounds like he would need to know, even though it sounds to me like a bit of a gray area, right? Because you're an inheritor, you didn't live through this, that you would know that there are witnesses or that there is some kind of documentation. So the fact that you said I have no witnesses is, well, okay, because you didn't live through that that lending of money or that whatever it was that the litigation is about. Okay. Number 10, final halacha in this chapter. Following rules apply when a person affirms his consent to the following agreement with a kinyan. Right. Active acquisition. If he does not come on this and this day and take an oath, his colleagues, that's one. His colleague claims that claim would be accepted, and that the colleague would, and his colleague, and his colleague would take whatever he claims without taking an oath. That's one. Yeah, if he affirms that. Alternatively, if he does not come on this and this day, take an oath and collect his due, he forfeits his right to the claim. Nothing is to be granted him, and his colleague is released of liability. Should the day pass and not come, submission is binding, and he forfeits his rights. Right. So, because he affirmed his consent, right, by a kinyan. So therefore, and he said, if this by this and this day, if he doesn't come, my witness, right, and take an oath, that your claim you can take without an oath. Right. If, however, he brings proof that he was held back by force beyond his control on that day, he is not bound by his agreement. He may take the oath against the claim issued by his colleague as before, so it does apply in analogous situations. Okay. Thank you, folks. Have a great day. Oh. Amazing.